بسم الله الرحمن الرحيم والصلاة والسلام على الصادق الأمين والسلام عليكم ورحمة الله وبركاته. Thank you for helping hands for organizing this webinar about legacy giving and organizing your affairs. As the Quran says, كل نفس ذائقة الموت. So it's a matter of time that we will meet our Creator, and planning for that to make it easier for our families is important in one of the maqasid al-shar'iyya. So the way I'm going to go about this is to make this more interactive. I want to take questions. Generally, I've been a lawyer for 27 years. I taught Islamic law at Rutgers Law School for 17 years. My practice has been, without exception, representing Muslim families for the past 27 years and Muslim clients. So I'm very in tune to our cultural needs and the legal and religious needs of our community. So Sharia Wiz was launched to take my 27 years of expertise representing Muslims and to try to create a website, an online platform that would allow everyone around the United States access to this expertise, making estate planning and family planning accessible, easy, and affordable. So the best way to start is that all of you should know that you need to have a will or a trust in place, because without a will, you're going to have all your assets frozen until you get in front of a surrogate court judge, until somebody gets appointed to administer. In our community, as you can see, these things can really complicate, delay distribution, and hurt families, lead to unwanted litigation and fights on who should be the administrator of the estate and so forth. Same thing, you need a trust so that you could avoid probate. The difference is between a will is going to appoint your executor, it's going to cover your burial, and it's going to cover your guardianship for minor children. But you still have to probate it, still has to go to court. A trust, on the other hand, does everything that the will does, because the trust also includes a will, but it avoids probate. If it's properly funded and properly set up, it will be an instantaneous transfer, smooth transfer of management or transfer of assets after the person passes away. So I'm going to illustrate to you how simple, I'm going to do a demo, showing you how easy it is to basically create an Islamic will that is Sharia compliant and state specific. Sharia Wiz is the documents, the trust are all state specific. So this would be in Massachusetts, it would be legally valid under Massachusetts law. Now, some people may need more complicated estate planning. In Massachusetts, which, another disclaimer is that even though I'm a lawyer and I've been practicing for 27 years, I practice in the New York, New Jersey area. I'm not providing you with any legal advice during this workshop and this demonstration. I'm not your lawyer. I'm not giving you legal advice. I'm giving you general legal information, specifically faith-based Islamic inheritance information. And that's the reason why you come to this website and you create your own inheritance and will and trust documents. In Massachusetts, I'm going to give you just general knowledge. There is no inheritance tax, but there is an estate tax. Meaning, if your estate assets are over $2 million, there's an estate tax when you pass away, ranging from 7% to 16% on what's above the 2 million. Now that 2 million is for each individual. So if you're married, you will be able to have 2 million for you and 2 million for your spouse. But they are not portable. So when you create, if you need to make sure that you cover the 4 million, you have to create what's called a pass-through, a bypass or credit shelter trust to make sure that you suspend the 2 million for one spouse in the trust until the survivor passes, and they would be separated, so you will get the benefit of the 4 million exempt from estate taxes. So with that proviso, let's see how we would create a simple, easy trust will. You set up your account, which requires an email, and you create a password, and you click start your product. You pick which product you want, whether it's a will or a trust or a family waqf. And these are the questions that you're going to go through. Are you married? And is your spouse living? Do you have children? If any of your children are non-Muslim or stepchildren or adopted, if you say yes, this would impact the Islamic inheritance calculator. So create your family tree. You pick which school of law you belong to. Is your father alive? Yes. Yes. If I said my mother is not alive, it would ask me about grandmothers. And this is one of the most sophisticated Islamic inheritance calculators in the market. And each question also has explanations if you don't understand them. How many sons, how many daughters? And after you finish your family tree, it's going to give you a breakdown of what are the shares. This estate is 6 shares. 1/6 goes to father, and 5/6 go to the son. If you click here, it gives you the explanation of the rule and gives you the authority that's in the Quran. Continue to the will. Now we focus on huquq Allah. If there's any zakat that we need to take care of. If anyone's going to perform hajj on your behalf. If there's any nizr that you have announced. If there are any kafarat, expiations that you needed for not fasting and so forth. Next would be debts to family and friends. And many of you in our community, we as Muslims, we're extended families. We're not the nuclear family. It's the uncles and aunts and cousins. And money is always traded, transferred between us. Most of us, when we bought our home, we had to ask our brother, our uncle, our friend to give us some money to help us for the down payment. These are debts that if you don't acknowledge in your will, God forbid, you pass away, they're never going to get paid because people don't know about them. So this is your opportunity here to document all of the debts that you have. If you say yes, you would start listing what debts you have. So now we're finished with debts. Now we're going to come to the bequest section. And this is leaving a bequest for a non-legal heir. Sunni law says la wasiyya li warith, which means that if you are already inheriting as an Islamic heir, you're not entitled to receive an additional bequest from the person who's passing away. But you can leave bequest to a relative or a friend, Muslim and non-Muslim, bequest to your grandchildren, to adopted children, and to charitable organizations. And you're limited by 1/3 of your assets to go to charities. So if you look at the charitable bequest piece, because we're working with Helping Hands, You know, the Prophet Muhammad sallallahu alaihi wasallam had said, when a person dies, all of his or her good deeds end, except three of them: a sadaqah jariyah, knowledge that benefits people, or a righteous child who prays for him or her. So sadaqah and organizing our estate plan is part of worship in Islam and is part of the Quranic moral message. So has always been very important that we plan our charitable giving in our lifetime, and also leaving a sadaqah jariyah or bequest to charity after we pass away. So if you say yes, you will end up answering a few questions. And it will populate all the necessary language to leave a bequest. So now we're done with almost everything. Now we have to come to the section of estate management. We're going to select who our executor is going to be. We're going to select who are the guardians for our children. We decide, when do the beneficiaries receive their money? Should they receive it at the age of majority, or do you want to enter a specific age for them to receive their inheritance? Then we come to burial. You specify about autopsy. These are the options: required by law, executor shall decide, family, or I don't consent. Where do you want to be buried? You can decide, I wish to be buried in a specific place, or I'll leave the decision to my family, or I leave this decision to my executor. And given that a last will, an Islamic will, it's your last statement, your last wishes that you have documented. Like the Prophet said, sallallahu alaihi wasallam, don't sleep one night without having all of your affairs written in a will. So we want you to have your voice. So this is your final instructions, where you would be able to, I want my children to be charitable, take care of your grandmother, make sure you do well in school, please, take care of your wife, I love you, and I'm sorry if I did anything bad during my life. Your entire instructions, final wishes, is your voice in this process. So once you're done with that, you're finished. You just finished your Islamic will in under 10-15 minutes, and you'll get to look at it here in draft and review. And you could go back to your dashboard and you could download the document, and each document comes with detailed instructions of how to complete the signing and witnessing of your will. So you got these detailed instructions, and this is the beginning of your last will and testament. It covers all of your issues, from family to the distributions and huquq and so forth. So that makes it very simple. You're done with a will. The same would be for a trust. A trust is more complicated. Instead of 15 minutes, it's going to take you, an individual trust, maybe 20 minutes or 25 minutes. In the trusts, you will be required to enter all of your assets, because in the trust, you create a trust, and after you create it, you need to fund the trust, which means transferring certain assets, your assets, into the trust, changing the deed of the home, assigning interests to LLCs or corporations, assigning your personal property, contacting your bank and tell them you want to change the title of your bank account to your trust account, and so forth. So this is the entire process to prepare your estate plan online. After you finish the will, you also, on Sharia Wiz, when we say an estate plan, we mean it's a will, but it's also a living will, healthcare directive, and also a general power of attorney. So these documents, you get to complete them in the process as well. So you will create your healthcare directive, your power of attorney, your HIPAA authorization. All of these documents are part of the estate plan, what we call will-based estate plan. The same applies for a trust. It'll be a trust, an Islamic will, healthcare directive for each party, HIPAA authorization, power of attorney. So I think that gives you a good intro to how you can prepare your estate plan online. And I suggest that we open the floor for questions. I find engaging with attendees is a lot more productive than me sitting down and lecturing you about Islamic law of inheritance and American estate planning. So any questions, let us know.
Brother Abid, once I complete my will, what do I have to do? Does it have to be registered? Has to go somewhere?
When
or where does it go? What happens?
When you have the instructions specifically tell you what to do. And to summarize, you need to keep the original. Only the original is valid. Keep it in a safe place. We recommend that you buy a fireproof box so that you can save it just in case there's a fire, that you preserve it. We don't want you to put it in a safe box, because then the person who you leave behind may not have authorization to go into the safe box. So then we can't even find out if there's a will. We recommend that you tell your executor that you prepared a will and where you are keeping your will. The same applies with the trust. Not the trust or the will doesn't have to be registered, but when you pass away, it needs to be probated. It needs to be filed with court. But a trust, it does not have to be registered in any location. And when you pass away, it doesn't go to court or have to be registered. Your successor trustee takes over the assets instantaneously and is able to manage and distribute the assets in the trust according to your wishes that are set forth in your trust.
Do we have to have both, or we can have just the trust?
Well, there's a will-based estate plan, meaning an estate plan that is based on a will. That would be a will, healthcare directive, and a power of attorney. When we do a trust-based estate plan, that would be a trust, a pour-over will, a power of attorney, and a healthcare directive living will. So yes, when you do a trust, it would always have a will with it.
In the case, what Brother Zahid asked us a question before we started it. You are based in New York and New Jersey. We need a will in Massachusetts. How does that work?
Well, again, always advisable. If you could afford, you can hire a lawyer. You can find lawyers in Massachusetts. I've been struggling to find an estate planning lawyer in Massachusetts that does Sharia compliant estate planning. Or you could do it on Sharia Wiz, because Sharia Wiz is state specific in all states except Louisiana. So if you have a simple, not complicated estate, lawyers are going to charge, for a will anywhere from $1,000 to $1,500, for a trust anywhere from $3,000 to $5,000. So on the platform, it's very convenient, it's very easy. You control your time and you can set it up within minutes. And you save substantial amount, and it's Sharia compliant. All our products have been approved Sharia compliant. Now, the other things that Sharia Wiz has that also is based on, my 27 years of experience and almost 35 years studying Sharia, is that we provide also some Sharia compliant solutions relating to inheritance with wives. So for example, on the platform, if you say you're married, you will have an opportunity, if you wish, to give a life estate to your wife or your husband in the house, so that if you die, the survivor stays in the house until she passes or he passes. It allows you to add an acknowledgement of debt that your wife has contributed. Let's say your wife had left her career and she helped you manage the assets in the marriage under the Sharia, that would entitle her to a piece of those assets. You can acknowledge that in your will if you wish. The same thing with the mahr. Maybe when you got married, it was a very low mahr. But if you voluntarily wish to increase your mahr during your marriage, your wife will receive whatever that mahr is, plus the 1/8 if you had children. So we have like unique solutions that are not available anywhere else. Also, our family waqf structure is probably, the most popular product on our platform, because it's a waqf ahli, which the scholars have been using for 1,300 years. And in the waqf al-ahli, what we do is you and your spouse put all of your assets into the family waqf. A schedule of assets for your wife, schedule of assets for husband. When husband passes away, the schedule of assets that is his assets, they are not distributed. They remain in the trust under the management and control of the surviving spouse. And the objective of the surviving spouse is to preserve those assets, use them for health, education, and what you need for support, but preserve the principal at all costs for the decedent's Islamic heirs. And when the survivor passes, only then will the trust terminate, and there'll be a distribution to the wife's Islamic heirs and to the husband's Islamic heirs. So that structure of a joint trust, which is a family waqf, is a very popular structure, and most financial advisors recommend. And that's also available on the platform. The prices are $199 for a will-based estate plan, all 3 documents. For an individual trust, it's $499, which includes all of the documents I told you. And for the family waqf, it's $799. We also just released last year the first Sharia compliant prenuptial agreement. That's also part of planning. So if you are getting married and you want to stay within the tradition in the event of a dissolution, you could do that also on our platform as well.
I will add that here. Sorry, Sajid bhai, 1 minute. I'll give you in a minute. I'll add it here, what Brother Abid just said, $149 for the basic will. Helping Hand is gracious enough to sponsor the first 50 donors, supporters who will reach out to Sharia Wiz. It will be 50% off, if I'm not mistaken, or it might be So reach out to me and I can share the codes with you. So when you go in to do your wills, you can use that code to get that discount for first 50 customers. Ji, Sajid bhai, you want to ask a question?
I have a couple of questions.
Please.
Is there a difference? What is the difference between the trust and will-based trust? And number two, after someone has created the will and the trust, who is going to review it that there's no mistakes or things left over to be filled in?
Well, first, I explained to you the difference between the trust and the will. A will is enforceable when you pass away, and it has to be probated in a probate court. A trust becomes legal and enforceable the moment you sign it. So one document says when you die, your assets are going to go and be distributed through court orders and appointments of the court. In a trust, you don't go to court. It's a private matter, and your successor trustee manages everything. With respect to mistakes, Sharia Wiz is a platform that's not a law firm, but all of our documents have been vetted, and they are built by lawyers and Islamic law experts. It's very difficult to make many mistakes, but it's your obligation to review your documents to ensure that you have the spellings and everything done. The software does create everything for you based on your inputs. So if you're able to edit, you're able always to come back to your platform and click edit and fix anything that you made. But if you want a lawyer to do it for you, then you have to hire a lawyer. And if you have to hire a lawyer, that means you have to pay for that lawyer.
I'm sorry, what I was saying was you mentioned about will-based trust.
No, there's only will-based estate plan and trust-based estate plan. There's no will-based trust.
What he meant in his description was when you make a trust, you have to, by default, make a will in order for the trust to continue.
No, not that. The reason why is when it comes to burial and guardianship, those cannot be in a trust, they have to be in a will. So that's why when you do a trust, you still get a will. The other reason why you have a will, a trust, you have to fund the trust. So let's say you put 5 apartments and houses in the trust and you changed the deed, but you forgot to put another house. So that house is not in the trust. So the trust doesn't govern. That property that you didn't put in the trust has got to go to court. So we have the will telling the court, by the way, anything that's going to get in front of you with assets from this guy, from me when I die, I have a trust that I created on such and such date. So all I ask you, judge, is to send those assets back into the trust so they be distributed according to the terms and conditions of my trust. That's why you always have to have a will with your trust. And it's called a pour-over will as a catch-all to protect you in the event that you didn't transfer everything into the trust.
I have a question.
Please.
Assalamu alaikum. I do have a question here in Texas. So if we do issue the trust, is that gonna cancel the probate case for the deceased when you are doing a trust? All the asset is not gonna go through probate?
Exactly. If you create the trust in Texas, which Sharia Wiz is in Texas, your assets will not go to probate. So let's say you put your son as a trustee. So you passed away, immediately your son has access to everything, access to bank accounts, access to this, all of your assets, and he's obligated to distribute them according to what's in the trust. No court.
Okay. Okay, no, thank you for that. I learned the will could be challenged from other beneficiary for the person he deceased. My question is, when the will already in the court and the probate issue, is that trust issue can cancel any will can happen from somebody else came to the probate?
No, first, this has to happen before the person dies. So you have to create the trust before you pass away. And if you create the trust before you pass away, yes, there is no court.
No one can challenge the trust, but they can challenge the will inside.
Well,
the
the thing is that the people can challenge a trust, but challenging the trust is much more difficult because in the trust, it does not require witnesses. It just needs to be notarized. There are some states that require witnesses, but I don't believe Texas requires witnesses. So once it's notarized, then, because most challenges are going to come only in two circumstances. Circumstance number one is that they are objecting to the authenticity of the document, of the will. Meaning, this is not his signature. There were no witnesses. That's on the formalities. In a trust, because you don't need witnesses and it's notarized, it's very unlikely to have authenticity arguments and witnesses not being there. But more importantly, is that with a will, you have an obligation to notify all of next of kin. So there has to be notices to everybody in the family. In the family trust, you don't have to notify anybody. You just have to notify the beneficiaries. You don't have to notify the entire family. So it is, the other thing is that with a will, there's going to be a question on whether you signed it voluntarily. Did somebody force you to sign it? Did somebody coerce you to sign it? Did you have capacity to sign it? So those are some of the arguments in a will, which are a little bit more difficult to prove in a trust, because in a trust, you create the trust and now you are running your life according to the trust, because the trust starts from the time you sign. So it's very difficult for somebody to come, oh, somebody forced him to sign. Well, he's been operating as a trust for 5 years. So if there was any problem, that would have been discovered. So there's like that safety valve in that. The other thing is, somebody would challenge the will or the living irrevocable trust if you are a spouse. So in America, you could disinherit everybody. The only person you cannot disinherit is your wife or your husband. So under the Sharia, if you have children, a wife is going to receive 1/8. But she can go and contest the will and say, I want my rights under Texas law. And under Texas law, there's probably an elective share. And elective shares around the country go between 25% to 33% of the estate. So you can contest and take the elective share, and then the balance of the assets will be distributed according to your will or according to your trust. But with Sharia Wiz, every will that is a person says he's married, or in a trust that says he's married, includes a state-specific elective share waiver. The husband waives all his rights to inheritance in exchange for his Islamic inheritance. A wife waives all her inheritance rights in Texas in exchange for whatever she's going to receive under Islamic law. So these documents are also included in the Sharia Wiz platform.
Thank you, Jazakallah khair.
Brother Kashif, do you want to ask the questions? I see you have
Yes.
noted it in the chat.
Assalamu alaikum wa rahmatullah.
Walaikum assalam.
So I want to ask, do I need to transfer the assets to the trust immediately? And what is the process of transferring the different types of assets? For example, I have a house that I want to leave. I have one daughter and my wife. So I want to leave the house for my daughter. So how do I transfer the house or?
Here's the issue. If you only have a daughter, under Sharia, your daughter receives half of the estate and the other half has to go to your siblings. So that would be the only way to do the Sharia compliant setting. If you want to deviate from that, you're going to have to hire a lawyer. Because on Sharia ways, it will not allow you to disinherit the siblings because that would not be Sharia compliant.
Okay.
So if you retain counsel, yes, very easy. Create the trust. It'll be a joint trust, you and your wife. And you could then say, when both of us die, the house goes to my daughter. Well, she gets everything anyways. Now, if you have, so here's how I can explain. If your assets are $1 million, $500,000 in a house, $500,000 in other assets, you could give your daughter the house against her inheritance. So she will end up receiving the home, but the other half $1 million is going to go to your siblings. Now, I have clients. Now, this is talking here as an attorney in New York and New Jersey when I have a case like yours. Some clients would say, that's it, half to my siblings. Other clients would say, I spoke to my siblings. They all, my parents, everybody said, we don't want anything, all of it to go to your daughter. And some feel comfortable and they will just do the Sharia compliant, except giving everything to the daughter based on the consent of all of the other heirs. Strictly speaking, that's not acceptable, but the Sharia says, yes, you can waive your rights to inheritance in favor of the daughter, but that has to happen after you pass away, not before. But some clients say, we accept it in our lifetime. Another school says that if you had a son, that son would block your siblings. So your son and your daughter would get 100% of the house, double the share for your son compared to your daughter. There is an ayah in the Quran in Surah An-Nisa, verse 174, 176, that discusses what is the inheritance from a sister. So the Quran says that if your sister passes away with children, you are blocked. You don't receive inheritance as the brother. So the brother does not inherit from his sister if his sister has children. And the Quran does not specify gender. It's gender neutral, which meant if she had a daughter, you would not inherit. And if she had a son, you will not inherit. This is not the acceptable mainstream position, but it is one particular reading of the Quran as it pertains to blocking siblings.
So I guess the other, sorry, one last question. But I am allowed to, in my life, I am allowed to hiba the property.
100%. In your lifetime, you can do whatever you want. But the problem is if you give it to your daughter in your lifetime, she does not get the benefit of the step-up basis. So let's say you bought the home for $100,000 in 2000. Now the house is worth $500,000. If you give the house to your daughter when you pass away, she gets step-up basis, meaning the cost basis for your daughter would be the $500,000. So if she sells the house for $500,000, she does not pay any capital gains. But if you put the house in her name in your lifetime, her tax cost basis will be the $100,000. So she will pay capital gains on the $400,000, unless she's living in the house and it's her primary residence. So that's why one of the biggest things in generational wealth transfer is transferring real estate to your children with the what we call step-up basis, tax-free, no capital gains.
Jazakallah khair.
Brother Abid, I have a question about the will. So I do have my will, but recently I was thinking, if I don't want to be, God forbid, I died by an accident or sudden death, I don't want to be autopsied.
So you could go to Sharia Wiz and you create your new will, because the new will cancel the old will. The Sharia Wiz will give you everything from no autopsy to your living will to your power of attorney. So it covers everything.
My question to you, do I need, does my will have to be notarized?
Yes, and witnessed.
Okay.
And that's what I'm
Is that-
telling you. You can go on Sharia Wiz, 15 minutes, and it will cover all of these items that you are concerned about.
Okay, Jazakallah khair, Barakallahu fiqh.
No
Yeah,
problem.
and at the end, Sister Fatma, you'll get a document which will tell you step by step what you have to do after you have completed the will and have it printed.
Okay, thank you, Brother Humayun. Jazakallah khair. Subhanallah, I just, I had, I lead the funeral team, and subhanallah, it happened that a person needed autopsy. The family refused, and then subhanallah, the hospital said if there is no will notarized by a lawyer, then she has to be autopsied.
Yeah,
And it's the worst thing that can happen to a deceased person, subhanallah.
I
May
understand.
Allah protect us.
Yeah.
Assalamu alaikum. I have a question too.
Alaikum salam.
Yes.
My question, like I think previous brother asked a second part of his question. If we make a joint trust with me and my spouse, do we have to transfer the assets into the trust? How are the
Yes.
assets going to be
Everything has to
transferred?
be transferred to the trust, Sajid. If you don't transfer to the trust, that means the trust doesn't have any assets.
But how would you transfer the assets? Is there a cost associated to transfer the assets?
Well, you're going to do all of that work, so it's not going to cost you. When you buy the trust on Sharia Wiz, you get also a trust funding guide. It gives you explanations of every type of category of asset and how to transfer it into the trust. It will also include some form documents for you to fill out to transfer to your trust. The only thing that's going to be an extra cost is going to be the transfer of the deed. And that may range from $200 to $500, depending on if you go to a lawyer, a title company. That's the only additional cost.
What about if you have assets with the mortgages?
Doesn't matter. When you're transferring a deed to a living revocable trust, that is for estate planning purposes. It's not change of title to require new anything from the mortgage company. Now, if you transfer it to an irrevocable trust, of course, that's going to be subject to potentially telling you have to refinance. If you transfer it and put it in your daughter's name or your son's name, that's going to trigger a refinance, but not when you put it in a living revocable trust.
I see. I think the same thing goes with 401ks.
401ks and retirement accounts are not to be transferred to your trust. They remain outside of your trust. You just have to update your designated beneficiary forms to make sure they comply with how you want the distribution to take place. Because retirement accounts have a lot of tax implications, and we do not want to retitle inheritance retirement, because that would be considered a taxable event. So all of this is explained in your instructions. And we also have customer support. Anytime people have questions, they call our offices.
I see. Jazakallah khair. So basically, if I understood correctly, it's mostly the physical assets, they need to be transferred to the irrevocable trust, not the liquid assets.
Nope, the liquid assets are going to be transferred, but it's easy. You contact your broker. If you have, if it's not a 401, if it's not retirement, you have an account with Sharia Portfolio or with Azad or with Amana. You call your broker, say, I have a living irrevocable trust. He'll send you the forms, and it'll change the name from Sajid to the name of your trust.
I see. Okay, got it. Thank you. Jazakallah khair.
No.
Can you make the beneficiary as a trust for your 401k and rollover
Yes,
IRA?
you could, but I don't advise that without advice of counsel and unless there's a lot of money, because generally there are restrictions on when you're going to withdraw the money. So if the inheritance, if the IRA goes to your daughter, she has 10 years from the date of your death to liquidate. So she can have her own tax planning strategies on how to take out the money and when to take out the money. There are ways to put them in trust, but those are very complex and they involve people that have very large estates. So it's best advised to keep your designated beneficiary form updated and they will receive that money.
With respect to time for Brother Abid and everything, if there's no questions, we'll end. We will follow up with an email to all your emails with the recording, with Brother Abid's contact, Brother Fatma from Azad Management's contact for plan giving wise. But these both are available. They both are working with Helping Hand for Relief and Development to guide us in our ways of doing things too. So Jazakallah khair to each one of you for joining us tonight, and a heartfelt thank to Brother Abid for his invaluable guidance always. Alhamdulillah, we have learned how important it is to prepare our Islamic will and protect our families with faith and responsibility. Before we close, finally, I'll bring it to your attention two beautiful Sadaqah Jariyah opportunities through Helping Hand for Relief and Development. In 2021, HHRD established an endowment fund to make HHRD an admin-free organization. I would encourage you to visit hhrd.org/endowment to look at it and to contribute towards it. The next is the video. If you were with us in the beginning, we saw a video for a hospital we are building in Karachi, state-of-the-art, one of its kind, Karachi Institute of Neurological Diseases and Rehabilitation. Supporting Kindar means supporting life-changing care and leaving behind a legacy of healing and hope, inshallah. As you reflect on your will, your family, and your legacy, we humbly invite you to include HHRD Endowment and Kindar Hospital in your plan giving. Your legacy gift today can become a continuous stream of reward and a lasting source of benefits for those who need us most. May Allah subhanahu wa ta'ala accept from you, bless your family, protect your family, and make your generosity a light in this life and the life after for you and your four siblings. Jazakallah khair, Brother Abid. Jazakallah khair for everybody joining. Please remember all the less fortunate brothers and sisters in your prayers, in your du'as. They are struggling while we are enjoying our life very comfortably. So remember, the least we can do is remember all of them in your du'as. And Jazakallah khair. Assalamu alaikum wa rahmatullahi wa barakatuh.
Jazakallah khair, Brother Abid, and Jazakallah khair, HHRD.